Rise and grind, sunshines. It's time to wake up, get motivated. Welcome to Hamza's Advocacy. You got Leo here as your host. If you have not seen the other videos, we are talking about, rules of the court, federal rules of evidence, federal rules of civil procedures, judicial canons, Supreme Court rules, particularly in Illinois. But these rules here that I'm giving out, as I have said before in my prior videos, you have the same rules technically in your state, under your state's code. In Illinois, it's like ILCS, and other states, they have their own, they have their own UCC, they have their own rules of evidence, rules of procedure, judicial canons. So it all varies in every state. However, the most important law or rules come from the Constitution. No matter what, every state has to follow the Constitution. Every person or people, all people have to follow the Constitution. And so do the police officers, so do the corporations, so on and so forth. Maybe I say corporations already, but that's okay. If you haven't watched the video yet, which it doesn't seem like really anybody has, and that's fine, again, I do pray that these videos do start being watched. I know I said it doesn't really matter to me, and it's not about that it matters to me, but I believe these videos can help people. So basically where I'm at right now is that everything happens for a reason. I strongly believe that. And these are seeds, and the lips of wisdom is available to the ears of understanding. Okay, that's from the great Kabbalion. And so if everybody's ready, if anybody's ready, the videos will come to them. Okay? Well, the time before the last video, we was talking about the study guide of the Illinois civil procedures and evidence rules versus the federal counterparts. Okay? And then the video after that one, I went on like a little tangent because of what happened with the attorney's lawyer. Like I said, she was kind, she was respectful, but don't tell me I can't do something. My goal is now, excuse me, my goal now is to do everything I can to prove you wrong, such as buying a suit. I went out and got fitted, got me a really nice suit, and it looks spectacular. I can't wait to walk in that courtroom as a pro se litigant. I also can't wait to do a lot of things. But this one, I have 14 days for them to either file a reply. But she did say she was working on a response to my complaint. And what I believe they will do is wait till the very last minute to file their response. And the reason they do that is so they can catch you off guard. Well, with that being said, I already know what's going on. I have counter arguments for everything. I plan on going over, I wonder if I have them with me. I plan on going over all the counter arguments on this video within the next 14 days. So I'll probably start uploading a lot of videos. I have a lot of stuff here. I have typed up everything in response to, well, basically if they file a motion to dismiss for failure to state a claim, I have here, Federal Rules of Evidence 301. I created a bunch of presumptions, and they got to rebut the facts with evidence. And I created summary sheets, case overviews for the motion to dismiss. What I will say in response to that, we'll go over all this. I laminate everything too, and I created a response because I know one thing they're going to say something about is my trust. They will say, because they did ask for my trust when they gave us the lease. They asked if we have a trust. I said no, because my private financial instruments have nothing to do with my rent or this place. Just because I have a trust doesn't mean I have monetary funds. It's just a protection. It's an asset protection tool, and my trust is private. I don't need to share that with anybody. Anyways, I have one for my vehicle. I have a counter argument for the practice, because they might say that I'm trying to practice law without a license. I thought about all kinds of different stuff, and I won't have everything that I need, but I'm going to do the best I can, and I'm going to win. That's for certainty. Besides that, let's get started. I want to go ahead and talk about Illinois Supreme Court rules of Civil Procedure 201 through 219 versus the Federal Rules of Civil Procedures. This is a good one to talk about because it compares. So we have Illinois Rule 201, which is discovery scope. Discovery is what happens after. So basically, the defendant files their motion, and from there, I think the ambulances are here. I live in a veterans nursing home, basically. And so, anyways, Illinois Rule 201, discovery happens after they file their motion. You go into discovery, you hand over interrogatories, and you go through all these different things to discover evidence. So it's the same thing as Federal Rules Civil Procedure. See, the Federal Rules of Civil Procedure is actually the same in every state. That's the federal rules. So this is a broad thing to know. But broad discovery, anything relevant to the case, not just admissible evidence. So anything relevant to the case. It can be emails and text, and it can be files, private information, so-called private information. If it may hold evidence for the case, if it may hold evidence that there's a lot of mistreatment in this facility towards veterans and just staff, staff in general too, because I know a staff member who was priorly working here and he was mistreated, and now he doesn't work here, of course, but anyways, go on to Illinois Rule 201K, meet and confer. So this is another part of discovery. It mirrors Federal Rules of Civil Procedure 26F. You can go read this Federal Rules of Civil Procedures. They're very fascinating. That's much needed to know if you're going to be a pro se litigant, which you should become a pro se litigant. Everybody should know the law. Everybody should know how to stand on their own 2 feet. Everybody has the responsibility to have the ability to respond. So don't be ignorant. Don't be a wise ass. Be humble. Be confident. Don't be arrogant. Anyways, before filing a motion to compel, you must certify you tried to work it out with the other side. So that's basically what meet and confer is. You meet and confer. You try to. This is discovery. You try to pull up evidence. They don't do so. You go ahead and file a motion to compel. The court compels them to go ahead and hand over whatever it is that you're trying to get, because it could be potential evidence for the case at hand. Going on to Illinois Rule 213, written interrogatories and witness disclosures. So this is very fascinating. This is part of discovery. Again, similar to Federal Rules of Civil Procedure 33. You can serve written questions. Parties must answer in writing and under oath. Parties must also disclose witness and options or opinions. Parties must also disclose witnesses and opinions that they'll use at trial. Okay, so that's something you have to put into your interrogatories, and I have to be prepared for that. I don't think I have anybody that's going to be willing to go to trial. However, I don't know yet. I pray that I do. I'm going around this weekend, and I have a petition. I'm having tenants basically sign this petition, and I'm going to use this as evidence. It'll be to make my case stronger. It'll be to make my presumptions stronger. I made presumptions, and so to make these presumptions stronger, I want to get basically an affidavit from my fiance is what I'm working on, and the other one is, like I said, the petition. I want to get at least 11 to 12 residents to come and sign this petition, and this will basically, it has a statement at the top. I can bring that in and read it sometime. But I want to carry on with this. So we have Illinois Rules 214, request to produce documents. So this mirrors Federal Rules Civil Procedure 34, and it lets you demand documents, the emails and records and tangible items. Okay, and then Illinois Rule 216, request to admit. Very powerful tool in Illinois forces the other side to admit or deny facts, genuineness or documents. Can't read this morning. Maybe that will help. Okay. If they ignore it, it demands, or it's deemed admitted. Okay? If they ignore it, it's deemed admitted. So silence is acquiescence. Illinois Rule 219 sanctions, like Federal Rules of Civil Procedure 37. If the other side refuses discovery, the court can sanction them. Fees, default, striking, pleadings. That's a big one. Rule 401 to 403, relevance and prejudice, identical to Federal Rules of Evidence 401 to 403. Only relevant evidence allowed. Prejudicial evidence can be excluded. So we have character evidence, mirrors Federal Rules of Evidence. Federal Rules of Evidence 404. No bad character, evidence to show someone acted the same way. Okay. And then we got Rule 602, personal knowledge. Same as Federal Rules of Evidence. Witnesses testify only about what they directly perceived. So you can't talk about, you're under oath. Got to be very careful. And being under oath, you can be held in contempt of court, and that's perjury. Be proven wrong, and that's perjury. You're purging yourself. Okay? And that's some time. So you don't want to do that. Okay? And then we have Rule 602, personal knowledge. Same as Federal Rules of Evidence. Witness testifies only about what they directly perceive. Oh, that's what I just read. Boy, I need to wake up this morning. My apologies. Oh well. I just worked out too. Ugh. Okay, going on to Rule 801 to 802, hearsay. Okay? Same framework as Federal Rules of Evidence. Out-of-court statements are generally inadmissible unless exception applies. Out-of-court statements are generally inadmissible unless exception applies. Okay, so hearsay. I got to think more about that one. That one's fascinating. I got to think about that. Authentication, same as Federal Rules of Evidence. So this is the emails, the text, the documents must be verified by testimony, stipulation, or metadata. So metadata, I don't know what metadata is. It's just something I read online. I got to look more into that. So there's a lot of stuff in these I have to also break down. I'm just giving you the very surface level of everything that I'm trying to understand here. So then we go on to Illinois distinctives to watch. So basically in my case, what we really want to pay attention to is the request to admit. Rule 216, stronger than federal. If the other side ignores, fact is locked in, acquiescence, silence is truth. Courts in Illinois take this very seriously. Interrogatories, Rule 213. Illinois has pattern interrogatories, pre-approved sets. Judges don't like fishing expeditions. Use the pattern list and tailor extras. So that's something I have to be very on point with. And I have interrogatories ready. I need to read them again. And I need to consistently read them so I know what I asked and what I wrote. It's been some time. I write a lot. I write more than sometimes I want to. I like writing. I like typing. But goodness. Anyways, 201K certification. Illinois courts rule or courts require you to certify that you tried to resolve discovery disputes before filing a motion to compel. If you skip this, your motion may get tossed. Okay, so you have to certify everything. You have to certify you did what you said you did. You have to have proof. Okay? And then you go on the local court rules. Each county includes vermilion and may add procedures, deadlines, formatting. You'll need to layer those on top. So each county may add procedures that you need to add to layer on top of those. So deadlines, formatting. Every county, every city, every state has their own local court rules. So let's move on to talking more in depth about discovery real quick. I'm only at 14 minutes here. Why not? Discovery opens after the defendant files their answer to your complaint. So basically after they file an answer to my complaint, discovery opens immediately. So the process to this, let's see, process flow in state court. So the process in the state court, here it is. Here's a simplified version of this. So I filed my complaint, and then the sheriff process server serves the complaint, or the summons and the complaint to the defendants. In my case, 4 parties. Defendants files an appearance and an answer or motion to dismiss. If they file an answer, discovery automatically opens. Rule 201 to 219 apply. Okay, so those are the ones we just went over back here. 201 to 219, so 201. So that's discovery scope, meet and confer, written interrogatories, request to procedure or produce documents, request to admit, and then sanctions. That's Rule 201 to Rule 219. You may then serve interrogatories, requests for productions, and requests for admission. Later, you may schedule depositions. So depositions are where you all get in and talk. When you talk, you basically get in. It's like being under a spotlight. You're now under oath, and you're being recorded. It's with the court recorder or the clerk. Okay, so here soon I plan on doing this a lot more, I could say professional in a sense. I don't plan on doing it like this. I'm getting a desk. I'm going to do this when I'm awake. I'm going to record better videos. My phone actually has good quality. I'm happy about that, so I might just use my phone to make videos. But me sitting here at 5 o'clock in the morning, tired as all can be, trying to get myself going. I already worked out. I already did my squats and my legs this morning, and so now I'm sitting down relaxing after being up on my feet. Okay, let me go over these real quick. Here's some more tools to use in discovery. Okay, so interrogatories are written questions the other side must answer under oath. So participated in this decision to answer. So basically, I would ask Mercy Housing who participated in this decision to issue the lease violation. And then I would move on to request for production, ask the other side to turn over specific documents. So I would ask for internal emails, lease violation logs, or training policies, okay? And then we would go into request for admission, ask them to admit or deny specific facts, admit that no witness observed myself making threats. They have to prove that there was no witness. So how can you say I did what you say I did? You can't. And then we go into depositions or sworn record interviews. So you depose the assistant. So this is where I would depose the assistant property manager, which is Melissa Taylor. I don't even care to say her name anymore. She don't work here. She quit, and I'm pretty sure it is because of all this that's going on, which is great. One out the door, another to go. Or area manager Danielle Fravel. I don't even care to mention her name anymore either. I don't care to mention any of these people's names. It'll be public information, and it's all on public file anyways. We have 25LM147 is the case number. 25LM147. And it can be looked up on the public docket. It's all public. Depositions. Let's see. We went over depositions. Subpoenas. Yes, subpoenas force third parties to provide evidence. So I get surveillance footage or records from corporate headquarters. So tenant file request. As a tenant, you may also have a right under HUD state under HUD state regulations to view your own tenant file. So see the lease violation is officially logged, who signed it, etc. I have a copy of the lease, so technically I don't know if that applies. Let's see, discovery strategy in my case would be, let's see. So since I filed a civil retaliation claim, and my discovery, the documents I basically want to try to receive is the internal memos or emails between the assistant manager and corporate, policy documents showing how lease violations are handled, your complaint, my complete tenant file, any complaints filed against me, or if none exist, never mind, I guess, any complaints filed against me. And I don't think any complaints have been filed against me. I don't think that usually when you get a lease violation or a complaint against you, somebody would go ahead and they would go ahead and put something on your door. That's basically what they do. Any mention of legal advice they took, which could backfire if it contradicts their actions. So basically, from my understanding, they don't go and contact their corporate legal team. So people to depose, which would be the assistant property manager, the property manager, and the area property manager. So anyone in Mercy Housing's legal or corporate office who was involved in the response. And then what could discovery reveal? Well, that no one in Mercy Housing truly believed you were a threat, that they discussed retaliating for your legal language or complaints, that they had no legal justification and acted out of convenience or frustration. Even a single damaging email or inconsistent statement can dramatically shift a case. Discovery is where many cases are won, lost, or settled. So, real-world example, you send this request for production number 3. Please produce all communication between any Mercy Housing employees and legal counsel related to my lease violation dated June 6, 2025. So if they can't produce it, or worse, if what they produce shows retaliation, I have a stronger leverage, essentially, in my civil complaint. Okay, does the property manager have a contact? So here, does a property manager have to contact legal before issuing a lease violation? And if they say no, but they really should, especially for serious allegations, and that's something they should. This was a serious matter. Trying to say that I was threatening, bullying, all this other nonsense, this wasn't true. And so lease violations are usually issued at the direction of the property manager or assistant and based on internal policies, and then intended to document tenant behavior, not necessarily to escalate to court, at least at first. But if the violation includes accusations like threats, violence, that's what it was. Threats, violence, and harassment, it's legally risky, especially if the property is federally funded, like most Mercy Housing sites. The violation could lead to non-renewal or eviction. The tenant, like myself, has asserted legal rights in writing. If they didn't consult legal before accusing someone of an unconstitutional violation and then try to use that to deny a lease, it could look like negligence or retaliation in court. So in discovery, asking if legal was involved is key, because if they say yes and legal didn't advise the violation, they look bad. If they say no, they may appear reckless and retaliatory. If they hide legal involvement, that can sometimes be challenged via a privilege log. So a privilege log is a document that a party produces when they refuse to turn over certain evidence during discovery. Okay? And usually because they claim it's protected by legal privileges, such as attorney-client communications, and all that unnecessary stuff that they say. Okay, so what it includes is a list of documents communications being withheld, a description without revealing content of each document, the date, sender, and recipient of the document, the legal basis for withholding, usually attorney-client privilege, that's what it is, attorney-client privilege or work product doctrine. Why it matters in my case is because, well, let's say that I asked to produce all communications with legal counsel regarding my lease violation. They might say they can't. That's attorney-client privilege. Well, that's not the end of the story. they're required to list what they're withholding in a privilege log. They have to. It can be used as evidence, so the judge can decide if they are abusing their privilege to hide something damaging. If they refuse to provide a log, their entries are vague, I can challenge it. Okay, so let's see. Sample discovery, retaliation case. Here's a starters. So here's let's see. 25 minutes interrogatory. Sample discovery said retaliation case, state or federal court. 10 discovery tools. A mix of here's some interrogatories, requests of production and admission. So interrogatories, written questions under oath. Identify all the individuals who were involved in the decision to issue the lease violation against myself on June 6, 2025. Number 2, describe in detail the factual basis for the allegations of verbal threats, bullying, and acts of violence stated in the lease violation notice. 3, state whether any Mercy Housing employee consulted legal counsel prior to issuing or reviewing the lease violation against myself. If so, identify the dates and names of counsel consulted. 4, identify any other tenants who have received similar lease violations for bullying or verbal threats in the past 24 months. Okay? So, those are interrogatories. And then we have requests for production. So this is where they produce documents, requested documents. And basically, here we go. Number 1, produce a complete copy of my tenant file, including all lease violations, communications, complaints, or notes. Number 2, produce all internal emails, text messages, or memos discussing myself from May 1st, 2025 through the present. Okay. Number 3, produce a copy of all Mercy Housing policies or training materials related to issuing lease violations and responding to tenant disputes. There has to be some kind of training that goes on for these situations. They have to know how to respond to these situations. Corporate has to have guidelines for these kind of matters. And if they don't, then that can be used. It can be very strong in court. Number 4, produce all communications with any legal counsel regarding my, against me or the lease violation issued on June 6, 2025. I have these written in a way where I'm talking to them, not talking to myself, so I have to reword it in my head before I read it to you so it makes sense. All this I have copies of, and this is stuff I plan to make in court. This is stuff I wrote out on another document. I just put it into my study guide. I plan on taking all of this, and I want to make a book out of all of this. I've already made a study guide, but I'll take this study guide and turn it into a book. Here soon I'm going to have a really good book that I'm working on now. And I'm not sure how I'm going to publish it yet. I thought about just doing it through Amazon. I've heard that's a really good way to publish things now, and it's really simple, and I just want to make sure what I type it's sellable. I want to sell this book. I mean, I want this book to be everywhere. It's going to be amazing. Anyways, let me finish this, wrap this up real quick. Interrogatories and Illinois Supreme Court Rules 213. So yeah, interrogatories, they are the part of Discovery Rules 201 to 219 that I talked about in the beginning, which we touched which I touched in the study docs, compared to and they were compared to Illinois rules, federal rules, Rule 213 specifically governed interrogatories. They're limited 25 interrogatories per party, unless they get permission from the court. So I have a limit of 25 questions. I have 25 questions. I don't remember them, but I need to go over them. It's just so much I got this. It don't matter. It's a lot, but it's worth every second, every millisecond. It's worth it, absolutely. So if you're serious about this and you got somebody that's violating your constitutional rights, don't mistake your rights for privileges. Your rights are not privileges. You were born here. These are your God-given rights. Stand up for them. So they must be answered in writing under oath within 28 days of service. All interrogatories, 28 days of service. And that's why I have 14 days for them to respond. The 24th of September was when Mercy Housing received their civil complaint. Well, they received their summons, is what they received. Now I'm just waiting for the 24th, and we'll see what happens from there. So the interrogatories, yes, Rule 213, this is how they work. I send interrogatories by mail. Certified mail is highly recommended. So certified send receive. I don't care what they say. They say the ladies at the post office will try to get you to do everything online. You can get the green slip back online, and I don't like that. I like the tangible piece of paper, and so that's what I always request for after discovery opens once they file their answer. So yeah, so I file the interrogatories by mail, certified send receive after discovery opens, and that's basically once they file their answer. Okay. Also must file a notice of service of interrogatories with the court, but not the interrogatories themselves unless ordered. So basically what I would do is a notice of interrogatories, I would write up a certification document, or draft up a certification document, and I would most likely attach of course I would attach the certified send receive number for the postal service in that drafted document. And I like to take pictures of everything. Take a picture of your envelope and attach it to it. Put it on public file. So a typical process of this is draft the interrogatories, 25 questions per defendant unless leave is granted by the judge. Make 3 sets, 1 for each defendant's attorney, 1 for you, and 1 for the court file. Okay? Mail to the attorneys. If they haven't entered an attorney yet, you can serve the defendant directly at the address services, and then file a short notice of service of interrogatories with the clerk if it just says you serve them on X day. So the deadline, defendants have 28 days to respond in writing under oath. Well, this was the longest video yet. It was much needed. I haven't gone over this stuff in a while. I've been doing other stuff. I've been still studying. I study every night. I have a 4-week study guide that I'm working on. And I didn't really do it last night, but every night I'm going to go sit down and study certain parts of this process, these procedures. And I'm going to be as ready as I possibly can. As you should be. As ready as you possibly can, always. So, thank you for listening. Hamza out. Y'all have a blessed day. Take care. See you next time.